I think it's a perfectly legitimate question to ask whether or not the court is biased against African states. I think it probably is, but for reasons that are justifiable institutionally. And the job the court now has to do is to check its bias, its understandable bias, and look at the implications of the kind of procedural bias it's shown going forward. So let me qualify that, because it's quite a big statement to say the court's biased. What I don't mean is that personnel at the court have a colonial perspective. They think that the only problems are in Africa, that there are no problems elsewhere in the world that the court could be dealing with, but rather the court was set up to act as a court of last resort. Where there are already judicial proceedings underway, the court's mandate was to monitor those proceedings and to see whether or not they brought accountability. So right when the ICC was first institutionalised, there were various cases that were of concern to the prosecutor. They included Colombia and they included the DRC and Uganda. As we know, the court opened cases, open investigations and later cases in Uganda and the DRC, but not in Colombia. Now why? This looks like it's biased. Actually, the arguments that the ICC Office of the Prosecutor makes, and I think they're good arguments, are that there were processes underway within Colombia. So one of the issues that African states have with the court is whether or not it's coming in and taking over, doing a job of finding justice that the state themselves is entitled to do and responsible to do. So the court was respecting Colombian sovereignty and respecting the fact that the Colombian government had some very imperfect processes underway. There weren't such processes in the DRC and Uganda, and so the court took action. So institutionally, perfectly justified, however biased against African states. Now, that has continued, the court has continued with its focus on Africa, again for reasons I think are justified. But what's happened is we now have a perception of the ICC that it focuses far too heavily on Africa, that it doesn't notice when there are situations of very, very grave, very serious violations of international humanitarian law, international criminal law in other parts of the world. So the court must now, and is starting to, forcibly move its focus outside this continent, and as for instance has opened an investigation in Georgia. The prosecutor last week issued a statement on the situation in the Philippines, and these are very much the right things to do because perception matters. The justification institutionally is perfectly good, but the perception of the court as biased has become so strong that the court needs to actively work against that, and I think, as I say, it's starting to do so. So one of the questions one might want to ask, if there is this bias, is whose fault is it? And there are a number of culprits. So the court has not managed its own reputation particularly effectively. It's not the job of a legal institution, and the court, I think, has struggled to understand its role within global politics as well as its role as a legal institution. It has tended, and I'm talking particularly about the Office of the Prosecutor here, tended to hold fast to the line that this is a legal institution that shouldn't be intervening within international politics. However, it can't avoid but intervene in international politics. Therefore, the court needs to be mindful of its own reputation. And it could have done better. Now, this is awkward. Should a court employ its own PR people so it's seen effectively within international politics as a fair institution? I don't know. But I think one can say the court could have managed its own reputation better. But there are others who are at fault too. So African states have had unrealistic expectations. The lack of head of state immunity was clear within the Rome Statute. Perhaps there was a perception that the court wouldn't go after heads of state, but I can't see why that would be the case. All of the discourse running up to the institution of the ICC suggested that heads of state would not be immune. So the fact that sitting heads of state are being pursued by the courts is not a surprise to anybody. Should not have been a surprise to African states. And so there is a fault again of perception on that side. Now I think, and I come from this from an international politics perspective, that the Security Council bears a lot of responsibility for the situation the court is in. The court is an institution that respects state sovereignty. Where states have signed up to be under the jurisdiction of the Rome Statute, then they are under that jurisdiction. What the Rome Conference did was set up a system whereby the most egregious violations of international criminal law could be referred to the court by the Security Council. And the Security Council has failed on a number of occasions to do this, which means that those states who are either permanent members of the Security Council or who are friends of permanent members of the Security Council are safe from the court. And this really makes it look like the court is biased because, for instance, there's been a number of attempts to refer Syria, and I think Anybody can agree that the situation in Syria at the moment is utterly appalling. There are quite clear violations of international humanitarian and criminal law going on, and yet the situation in Syria will not be referred to the court because of the relationship of Syria to Russia in particular. So for me, the ICC bears very significant responsibility because it has the power to make the court look like it is a fairer and less biased institution, and it is not using that power in order to maintain the interests of the states that are on the council. So what could be done about this? Are there practical ways that the perceived bias of the court could be ameliorated? And what I think is very unlikely to happen is the Security Council changing its behaviour. What could happen is the court could look again at staging cases within the African continent. It's looked, I think, in the DRC case in the past at whether or not cases could be tried somewhere, either in DRC or close to it. And the court concluded that the security concerns were too grave and it was not going to be possible. So very early on, as the court was first trying its cases, it looked to see whether or not justice could be brought closer to the victims of particular crimes. I think that needs to be looked at again. It seems to me to be extremely important that the people who are concerned about the potential bias of the court get to see the workings of the court, rather than just court personnel come to those countries which are under the jurisdiction of the court currently in cases being tried to say, this is what we are doing in Europe about your particular case. Rather let the court come when possible to the states that the case is concerned, or to neighbouring states, and try cases there, have the operations of the court take place in Africa so that people at least can see what the court does. And the court is a mysterious institution to many people whose cases are being tried there. It's a very long way away. It's staffed by people who they don't know the names of, they're unsure of what the mandate of the court is, why it seems to have all of these African cases, and so there's an information campaign that needs to be done, and I think it's done very effectively by having the court operate. So we know this from other courts. We know from the extraordinary chambers in Cambodia, from the special court in Sierra Leone, how important it is to have courts try cases in the places in which crimes took place where possible. And the ICC could work harder to be able to do that. But of course African states have a role to play there too. African states can offer their buildings, their security services, they could welcome the court to move some of its operations to particular territories. So simply bringing together people who have concerns to straighten out, to mean that there's a broader understanding of the role of the court and why it's operated as it has, I think would be really quite useful.